Welcome to, I think this is the fourth webinar I've done on biodiversity net gain. And with it still apparently coming into force in November this year, that's only 3 months to go. So what's the latest? So I'm going to, this will take, we'll be finished by 10:30. I will present some slides and then answer any questions that you have asked. Please use the Q&A button on your screen to ask questions about biodiversity net gain regime. If you have any technical issues, my colleague Megan may be able to sort them out if they're not at your end. Please use the chat function for those sort of things. I probably won't read the Q&A until I've got to the end of my slides, but please carry on putting questions on as we go through. I will say this again at the end, but we will, after the webinar is finished, I will write answers to all the questions, even the ones that I answered on the webinar, and send them together with the slides and the recording to everyone who registered to attend. So you don't need to take notes. And I hope you find it useful. So my name is Angus Walker. I am a partner at the law firm of BDB Pitmans. My day job, if you like, is development consent orders under the Planning Act 2008, but I'm becoming rapidly having a sideline of biodiversity net gain, as I think it is a revolution in planning. So I'm going to briefly recap biodiversity net gain. If you have attended previous webinars, there may be a bit of repetition, but I think I've got deeper into it, so you may still learn something new. I've divided up what people need to do into developers, landowners and brokers to prepare, and local authorities, since I saw a few people from local authorities have signed up. And then there'll be a Q&A at the end. So, as I just said, I think BNG, biodiversity net gain, is a revolution. In fact, I'm going to be as bold to say that I think it's the biggest change to planning since the Town and Country Planning Act 1990 came into force. It's getting more known about, but still, I would say the level of knowledge, even in the planning sphere, is not yet great enough. By my calculations, though, this will probably affect over 100,000 planning applications every year. And in doing so, that presents a challenge for those making the applications, but also an opportunity for those who might have some land that could be used for this BNG. And if you imagine all the land being taken up by planning applications every year, more than that amount of land will be needed somewhere else for biodiversity net gain. So that's instantly doubling the amount of land involved in planning. And it's usually more than the same amount of land again because of the net gain element. So that's going to be a lot of land involved. Right, start with the basics. What biodiversity net gain is. So from the start date, this November, some date in this November, I suspect something like the 30th of November, and every planning application made from that date will have a compulsory condition added to it when it is granted that the environment must be improved as a result of that planning permission being implemented by at least 10%. And the origin of this is the Environment Act 2021. For Town and Country Planning, it's section 98, which introduces schedule 14, if you really want the details. And when there's a link like that in a slide, when you get the slides, you'll be able to click the link to get to the source. It is coming into force supposedly in November this year for larger planning applications, in April next year for small sites, and for applications under the Planning Act 2008 for a DCO, Development Consent Order, not until November 2025. It will affect, there are some very small applications which won't be affected. So householder applications, if you're just putting a loft extension on your house, you do not need to provide biodiversity net gain. If the area of your red line is less than 25 square meters, that should be less than, not greater than, 25 square meters, which is not that big. That's a very large room. And even change of, oh yeah, sorry, the greater than is correct because I'm saying what won't be affected, whereas that bullet point says what will be affected. Even change of use applications will have to provide biodiversity net gain. So even if you're not doing any development, you're simply changing what land is being used for. If it has a non-zero existing score, then you will have to provide 10% net gain. This goes beyond planning because a market is supposed to arise of buying and selling biodiversity land, and indeed is already arising. So there's entrepreneurs already providing land and upgrading it to offer to developers. So when I nearly forgot. In fact, I did forget. My colleague Megan is putting up a poll here. So given this revolution that I think there is, do you think you will be affected by this regime? Simply answer yes, no, or not sure. I've got a couple more polls later to make this slightly more interesting. And it says panelists cannot vote. Well, I think I will be affected by this regime. But I'm forbidden from voting. So we'll just let that, please say what you think. Now we'll go on to how net gain is calculated. So the obligation is to provide at least 10% in improvement in biodiversity for at least 30 years. But 10% of what? Well, you have to score land according to a thing called the biodiversity metric, which is created by Natural England. There we are, 94% of people think they will be affected. I suppose that's why you're here. So it's a slightly skewed audience. But I think there are a lot of people who are unaware that they're affected. So thank you for participating in that. So what you do is you score the land you're about to build on according to the biodiversity metric, and that will give you a number in biodiversity units. Then you must improve some land somewhere else, or even within your site, such that the score of the improvement is at least 10% higher than the score you are losing. There are 3 ways of doing this improvement. So you can do it on site, obviously not on the bit you're just about to put a building on, if that's what your permission is for. So it'll be some other part of the site. Off-site, so that is generally where it's someone else's land that you are paying for them to create or improve land habitat. And then there's a third last resort on which there is some news. So this is what is called statutory credits. You simply pay the government a large amount of money, and that fulfills your obligation to provide biodiversity net gain. Incidentally, there are separate metrics for 2 linear measures that don't have an area in the same way, hedgerows and watercourses. So if you are affecting those, if they are on your land, or even if you're not affecting them, but they are on your land, you will have to provide 10% gain for each of those separately. So you can't say, oh, I'm doing 25% on the main metric, so I don't need to do 10% for the watercourse metric. I'm afraid you'll have to do at least 10% on each separately. You can't trade them between each other. But I'm not going to go into the details of those ones because that's too much. So we'll just focus on the main metric. Okay. So we're currently on version 4.0 of the metric, and apparently this will be replaced by what will be known as the statutory metric before it comes into force. but the main method of calculation is not going to change. So you get a score in biodiversity units. To get this score, you multiply 4 things together. It is worth understanding these, so you can get a feel for what BNG actually is. So the first one is the area of the site in hectares. The second one is a score depending on what the habitat is made up of the site. And you get a score between 0, 2, 4, 6, or 8, one of those 5 different numbers. If the distinctiveness of the habitat, according to Natural England, is very low, is low, medium, high, or very high. The metric has a list of 80 different types of habitat. And I put this in green because you'll need to employ an ecologist to work out the distinctiveness of the habitat. They may have to divide the land into more than one different type of habitat and score each one separately. Note that there is a very low 0 score, and 10% of 0 is 0. So that is another way that you don't have to provide biodiversity net gain, is if the land doesn't have any habitat on it, basically. It is hard standing or some other non-ecologically rich habitat. So most change of use applications will probably be entirely a 0 distinctiveness, and so won't in fact need to provide biodiversity net gain. But if they had a bit of grassland on them that was of some non-0 score, then the obligation would apply to them. The third thing you multiply is the condition of the habitat. You've got 3 options basically: poor condition, moderate condition, or good condition. And again, it's in green. The ecologist has to decide this. Obviously, you're going to, as a developer, want that to be a low number, but ecologists will not be swayed by such desires, presumably, and will do this objectively. And the fourth thing is the strategic significance of the habitat. So by that, I don't mean that your land has been zoned for development in the plan. I mean that the existing habitat is mentioned in the plan as something worth preserving. So if it is in a local plan, then you multiply it by 1.15, so that's not a huge uplift. If the ecologist judges that it is a significant habitat, although it's not in the plan, then it becomes 1.10. But if it's not in the plan and not judged significant, then that doesn't affect the score. So you multiply those 4 things and you get a score in units. And you're going to have to provide that plus 10% somewhere else. Did I have a poll? Yes, I did. So this question is asking whether you know the difference between statutory credits and biodiversity units. If you don't know the difference, don't worry, I will explain it in a bit. This seems to be the single biggest area of confusion, or not necessarily confusion, but use of the wrong terminology. So let's see if you actually own up to not knowing the difference between these 2 things. Meanwhile, I will move on to the next slide. So the land that is being improved, or a habitat is being created upon it to provide the biodiversity net gain, is also scored. And it is the same 4 things that were on the previous slide that you multiply together again, but you multiply them by 3 further things. Oh, that's the end of the poll. Let's see what the result was. Yeah, okay, so some lack of knowledge there, but 40% people do think they know, 38% don't know, and 22% are not sure. So let's hope that if we rerun that poll, although I don't think we're going to do that at the end, let's hope that is higher in the yes category. So as I was saying, the 3 extra things you multiply with the new land are the difficulty of creating the habitat, and that varies between 0.1 if it is a very difficult habitat to create, or 1 if it's an easy habitat to create or you've already created it. And And this is not in green because it is not up to anyone's opinion. You have to look up the metric for how difficult each particular habitat is to create. It tells you automatically. The second one is the temporal multiplier. So this is how long it takes to create the habitat to the condition you are aiming for. And again, you have no choice in that matter. You have to look it up on the metric. Each habitat, Natural England has decided how long it takes to create in a number of years to get to poor condition, and another further years to get to moderate condition, and need more years to get to good condition. Incidentally, as I'll explain later, it is always worth, certainly in terms of getting that higher score, to aim for good condition, because the discount of the length of time is always less than the improvement in getting to good condition in the score. Interestingly, that temporal score does not make the score any lower after a 30-year period. So if it's going to take 60 years to create this habitat, then that's the same score as if it's only going to take 31 years. So although you don't have any choice in how long it takes to create the habitat, you do have a choice in how long you are going to wait until you start to create the habitat, or perhaps you've already started, but you haven't finished. So that will make that a bit shorter. So you play around with the amount of time you are delaying, plus the automatic number in the metric to get a discount for the time. And the third one, and the last multiplier, is the spatial multiplier. So this depends where the land is that you are creating that's going to be used for this habitat compared with where the development is. If they are in the same local authority area, and this is at the district level, I presume it's at the level to which the planning application is being made, but I'm not entirely sure about that. So if you're making a mineral permission to the county council, does that mean it could be anywhere within the county? I might have to look that up. If it's anywhere in the same area, that does not affect the number. If it's in the immediately neighbouring local authority, then there's 3/4 multiplier. And if it's anywhere else in England, it's a half. I should probably have put this on a slide, but this whole regime is only applying to England. And I think the biodiversity gain land also has to be in England. But we'll have to wait for the details of the regulations and guidance to absolutely confirm that. Just to make it slightly more complicated, when the Natural England moved from version 3.1 to version 4 of the metric, they changed this spatial multiplier to make it have less effect. So it is only the difference between the before score and the after score that gets discounted by where it is, not the whole of the after score, if that makes sense. So if the land within your red line boundary has a score of 4, the new land that you are developing has a score of 6 until you apply this multiplier, then it is only the 2 extra that you discount with the spatial multiplier, not the whole of the 6. That makes it very complicated, but it does mean the spatial multiplier is less impactful, because I think that was in response to environmental bodies saying, well, we have all these lovely sites that we want to improve, and it would be really useful if developers were not discouraged from using them because they're too far away from their development. So although those 7 things you have to multiply together, the 4 at the top and the 3 new ones, the score must be at least 110% of the before score to qualify for the net gain obligation. So here's a couple of some examples. Since a lot of it is automatic, I worked out what the most highest scoring type of habitat for each distinctiveness you can create. But this does not consider the cost of creating the habitat, so I don't know if these are the most expensive ones. So if you're doing a complete cost-benefit analysis, you have to work out the cost of each type of habitat and then multiply that by the number of biodiversity units each one will create. But if the distinctiveness, if you have a low distinctive, no, if you have a medium distinctiveness land that scores 2, is it medium? No, it is low. Low distinctiveness land that scores 2, very low is 0, isn't it? Then the best thing you want to create is apparently allotments. And you can create, if you're losing 1 hectare of land of distinctiveness 2, you only need to create just over 1/3 of a hectare of allotments to fulfill the biodiversity obligation. If you're creating them to good condition, these are all good condition. If your land is of distinctiveness 4, the best habitat to create in terms of scoring is non-priority ponds, whatever those are. And that slightly more land will be needed. If it's distinctiveness 6, so that's medium distinctiveness, either of priority ponds and or temporary lakes, ponds and pools, those 2 types of habitat are your best bet in terms of scoring, but you will need more than a hectare for each one, for each hectare that is being lost. And finally, if you're the highest distinctiveness, then the best thing to create is lowland meadows, but you will need almost 1 3/4 hectares for every hectare you're losing for that. Obviously, these will generally be more expensive to create the higher up the distinctiveness ladder. These all have to be created to good condition to get the highest score. And it is always worth, as I said, going for a higher condition, as the temporal discount is less than the advantage of going for the higher condition. I just thought I'd create those to try and bring it alive a bit, the different types of habitat. So moving on, some additional points to note. So as I've said, it does apply to change of use applications. It does apply to brownfield sites, previously developed land, because even if it's been developed, habitat can be created and animals and plants can move in, and it has an ecological value, as you might expect. Even if you're applying only for a temporary use, you will still need to apply biodiversity net gain, although you could use the existing site if you're restoring at the end, and that'll help with much of your score, but that would be discounted by the temporal multiplier because it'll only be restored after a number of years. But that could be the bulk of your obligation, but you'll still need to find a bit of land because you need 10% gain plus any extra percent that has gone down because of the length of time that has elapsed. Similarly, if you are applying for a land where most of the damage is just caused by construction and then it will be restored, like an underground pipeline or something like that, then you will be able to count the land after it's been restored in your metric, but you'll still need some extra land somewhere else because that will never amount to 110% unless you're improving the habitat on the land to a higher quality or different habitat from what it was before. I should say that it is pretty much a numbers game, that you simply have to apply the numbers, but first thing is you can't, your new habitat can't be a lower distinctiveness than the one you're building on. You can't degrade the quality of the habitat, even if you have lots more land. There is an exceptional circumstances thing in the metric that you can negotiate, but and do something special for land. But the exception is, it really is exceptional when you read it. You have to have exhausted absolutely everything, and there must be something very special about your land. So I would not rely on the fact that you can do that. So the cost of biodiversity net gain, and I'll bring this into focus when I come to talk about credits, may influence your site selection if you have a choice of site. If the existing habitat habitats of the different sites are different. Some of them will be more expensive to replace than others, so that may influence the choice. So biodiversity net gain is going to come into factored in right very early on in your design of your development. Two further things to be aware of, two concepts: additionality and stacking. So this is, can I use my biodiversity gain land for something else as well as biodiversity net gain? And can I earn money from the developer that is wanting my biodiversity gain land, and also earn money for it for some other purpose at the same time? The answer is yes, in some circumstances. Additionality is the word about the different uses at the same time, and stacking is the word for the different payments at the same time. There isn't time to give all the detail of that, but the consultation response that the government provided earlier this year does give some examples where you can and where you can't do this. So it's definitely worth reading the detail for that if you are a provider of biodiversity gain land. Popular misconceptions. The first one is that because it's a 10% gain obligation, the idea that you only need to provide a 10% extra somewhere, but in fact it's really 110% of the land, because if you're obliterating land, that's your 100%, you've got to re-provide 110%, not just 10%. So do think of it as 110% obligation. As per the earlier poll, confusing units and credits seems to be the most popular misconception, and even people who are sort of well versed in this get these terms mixed up. So units are what the score of the metric gives you, so that'll be a number, and credits are the amount of the things that you get by paying the government, because you can't find any on-site or off-site land for your development to fulfill the biodiversity net gain obligation. So credits are essentially money, and are the last resort. And I'll come onto that in a minute in more detail, because we've got some prices now. So you definitely want to try and rely on units rather than credits if you can at all help it. And in fact, you might, depending on what the guidance eventually says, have to demonstrate that you did try to find the units on site, and then you try to find them off site before you can rely on the credits. Another misconception I've come across is that thinking that the habitat for your biodiversity gain has to have already been created before you can commence development. That is not the case. Remember that temporal metric. As long as the local authority is sure that it will be created, and the landowner or broker of that land has entered into agreement guaranteeing that it will be created, then it doesn't have to have been created at the time of the start of your development. Another misconception is that if you are a landowner providing some biodiversity gain land for a specific development, either your own one or somebody else's, will somebody nick it before you can allocate it to that particular development you had in mind? No. Putting it on the register won't mean somebody can take it, allocate it without you having any control over that. Don't worry about that. And a final one is, do those providing biodiversity gain land have to be accredited in any way? No, they do not. Anyone can do it. The land will have to be registered, and that has various obligations that I'll come to, but you as a person or company don't have any special features about you. No, excuse me. Right, let's look at it from the developer's point of view. What do they have to do? So if they're about to make a planning application after the start date, presumably in November, then a new document has to be submitted with the planning application called a BNG statement. And that has some general information about how the developer is expecting to discharge this obligation to provide BNG. So it rather vaguely apparent, I think, just has to say, well, we're going to do it on site, or we're going to do it off-site, or we're going to have to rely on credits, or we're doing some combination of those. Again, the government's consultation response document issued this February gives some more information about that. And it is certainly worth noting that if you're applying for outline permission or for a series of phases, then that BNG statement appears to be more complicated, because you have to say when you're going to do what through the phases, or when you're going to do the reserve matters application and all that sort of thing. So read the detail for those. Then, once you are granted permission, you get this condition applied to your permission that obliges you to have a biodiversity gain plan agreed with the local authority before you can commence development. And that plan obviously commits you to the 10% gain. And that has much more detail precisely about which land is going to be used, if it's on-site or off-site, or that you're relying on credits for some or all of your obligation. The initial consultation document has a draft template for this gain plan, which runs to 9 pages. And the government has undertaken to provide an update to that before the obligation comes into force in November. So that is the 2 stages for an application. And as I've already said, there are 3 options for BNG or a combination: on-site land, off-site land, or statutory credits. This will affect site selection, and I'll come on to the credits, but that gives you an idea of how much, although the cost of buying units from somebody will be a lot less than the credits, it will give you an idea of the relative prices of the different types of habitat. And this will definitely be a factor of the costs of your development. So let's look at on-site first. It is the simplest option. So if you have some land on site that is not being built upon, that has a habitat distinctiveness value, then you'll need to provide biodiversity net gain. If it's not already good condition, then you may be able to discharge the obligation to provide BNG in full, or at least in part, by improving the condition from whatever it is, poor or moderate, to good. You might even want to make your development slightly smaller so that you can provide on-site BNG, if that makes it, if that's worth it doing in terms of cost. So the next option is off-site habitat creation. So you are going to have to look for land either, or you may be able to create your own land somewhere else, create your own habitat. But generally the idea is to look on a national register called the Biodiversity Site Register, which will have land on it that landowners or brokers are providing for developers like you to use for their your development. And that will be pre-scored, so you'll know how many units that will provide for you, whether it will do the whole development or even more or less, and you have to have more than one site, for example, or maybe you've got some on site and this will be the remainder. Presumably the register, although it'll say where the land is, it won't have already been discounted for the spatial multiplier, because it doesn't know what development is going to be allocated to. So you will have to discount that from the score that's given in the register. And I'll come to what the landowner or broker has to do to put the land in the register in a minute, but they will have had to guarantee that this land will be in this made into this new condition and maintained in the new condition for the requisite length of time through an agreement. That agreement you would really ideally want to be compatible with your obligation to provide biodiversity net gain. And there may be an issue here that your local authority has a policy for providing BNG that isn't written in exactly the same terms as either the legal obligation in the Environment Act or as in the agreement that the landowner has made somewhere else So you need to make sure those are all aligned. And I think this is maybe a bit of a tricky issue going forward. I'll explain what a concov agreement is in a minute when I come to from the landowner's point of view. So that's the off-site creation. You look up the land on the register, you make an agreement with the landowner to use their land, and then you're done. There will be some money changing hands, of course. The last resort is to buy statutory credits from the government. And there has been a development in this area. The price of biodiversity credits was announced on the 27th of July. Slightly sneakily, it says, and if you read the small print, well, it's not particularly small, you do need 2 credits that are declared for every 1 biodiversity unit that you might need. This reminds me of a highly calorific food that has a serving of 2 servings per packet to make it look as though it's got some fewer calories. So although for example, all types of low distinctiveness habitat, that score of 2, cost 84. It says in the document that they cost £42,000 per credit. You'll need 2 credits, so it's really £84,000 per unit. If you have a medium distinctiveness habitat, it ranges depending on the type of habitat between, and again, 84,000, but all the way up to £250,000 per unit, depending on the type of habitat. So you'll need to not just rely on the distinctiveness score, but look at the broad type of habitat. Grassland is one of the £84,000 ones, and sparsely vegetated land is one of the £250,000 ones. So as I said, these give a guide to how much, although they will be cheaper. I mean, they'll definitely be cheaper, because otherwise, why even go to another landowner to buy units? But it gives you an idea that grassland units provided by landowners or brokers will generally be cheaper than sparsely vegetated land units. Then if you go up to the high distinctiveness, score 6 habitats, again, the lowest is still only £84,000, but the highest is a whopping £1.3 million per unit. Traditional orchards being an example of a high distinctiveness habitat that is fairly cheap, relatively, and peat lakes are one of the highest cost ones. So you really don't want to build your development on a peat lake if you can at all help it. I wouldn't have thought you were probably going to do that anyway, but there you are. The highest distinctiveness of all, the score of 8, you cannot even buy credits. You'll have to rely on on-site or off-site, some sort of bespoke arrangement. So those put into focus how expensive this whole venture is going to be, particularly if you've got a high distinctiveness habitat that is at the higher end of the cost schedule. So here's a poll. Might this cost actually mean you reconsider your entire development? Yes, no, or not sure. Remember that units being bought from a landowner or broker will be lower than this. But initially, I think there won't be very many units available, because the register is only going to open shortly before the obligation kicks in. So initially, credits may be relied on more than eventually will be the case. So say you've got a score of 4 for the habitat that you're going to build on in 4 units. You are going to have to spend, I think it's about £370,000 in credits to get the 4.4 that will be required. So that's quite a lot, isn't it? I got the main story in Planning magazine on the basis of that, working out that calculation. The answer is not sure. Some people are discouraged and some are not. Interesting, it's almost exactly equal. Okay, let's move on from the landowner point of view. So you're not developing land yourself. developing in terms of getting a planning application to build on something, but you are going to create a habitat or improve an existing habitat. So you do have the option of, if it's already in poor or moderate condition, you could upgrade it to good condition. Alternatively, you could create a new habitat from scratch on the land. And you must put land on the biodiversity gain register. As I've said, this will open by November, so that sounds as if it's not going to be very long, the same month as BNG becomes mandatory. So it's a good idea to get familiar with this now. There will be a fee to put land on the register that has not been precisely announced, but it will be between £100 and £1,000 per entry on the register. And I've taken a screenshot from the beta version of the register application process to show you what you need to put the land on the register. You need 6 things. You need the boundary of the land, the red line boundary, if you like. So that's not too difficult. Second one, if you are not the landowner, you will need consent from the landowner that you have the rights to create and maintain this habitat for the landowner. Thirdly, you need proof of ownership of the land. The land registry entry will suffice, apparently, for that one. A completed biodiversity metric for the land. It says 4.0 on there, but eventually it'll be the statutory metric. When it says completed, it won't actually be completed because it won't have the spatial discount if that's needed, because it doesn't know where the land that it is being used for is. But presumably it's completed for everything except that. You need a thing called a habitat management and monitoring plan, of which not much detail is yet available, but the government has promised a template for that. And one can assume, given its name, it'll set out how the landowner or broker proposes to manage and monitor the habitat and make sure it's kept in that state, and they can prove it's still in that state over the 30-year period. And finally, and my ears pricked up at this one, of course, a legal agreement securing the habitat enhancements for 30 years. There are 2 different types of legal agreement that you can use. One is a Section 106 agreement, which, if you're involved in planning already, is quite a familiar beast, although it would be a special version that is to do with biodiversity net gain. The other is a new thing called a conservation covenant agreement. Conservation covenants are things that have been introduced by the Environment Act 2021, just like BNG itself. There are no conservation covenants yet in existence because the body, whereas where you enter into a Section 106 agreement with the local authority, you enter into a conservation covenant with someone called a responsible body. And it was only on the 27th of July that the government allowed anyone to apply to become a responsible body. So no one is a responsible body yet, and therefore you can't enter into a conservation covenant agreement with anyone yet, but that'll happen fairly soon. A conservation covenant agreement is a bit like a Section 106 agreement, has several features in common, but it is more ecologically focused. It does run with the land, so if the land changes ownership, then the agreement still applies, for example, like a Section 106 agreement. So that's an alternative. Those are the 2 ways of proving that you are going to keep the enhancement for the requisite 30 years. Finally, for local authorities, from their point of view, I try to put myself into their shoes. As I mentioned, there may be a mismatch between how the policy of a local authority, because many local authorities already have a policy to require 10% biodiversity net gain, but it's not mandatory and is weighed against any other benefits of a project when deciding whether to grant planning permission. But the way that is phrased may not entirely align with the obligation that will come in November to provide biodiversity net gain. And surely it would not be a very good idea if developers have to comply with your policy separately to the mandatory obligation and do it twice, essentially. So I would suggest you check your policy and make sure it is aligned. You probably need to wait for the full regulations and guidance before you can do that, complete that check. There will definitely be a shortage of biodiversity net gain land on the register initially, given the short length of time between the register opening and the obligation coming in. So consider preparing your own land to put on the register. You might wish to apply to be a responsible body. You're familiar with Section 106 agreements, and this isn't too different, although there are quite a lot of obligations if you look at the application process, but it is something to consider. And I imagine the majority of responsible bodies will be local authorities, but there may be, Natural England has declared that it is applying to become one, for example. So there will be other organisations like that. There may be charities who have an environmental purpose who apply as well. If you are wanting to improve habitats in your plan, then name the sum of the land that you want to be used to be improved or extend a habitat, so that it gets that higher score in the when someone's calculating the metric, and that encourages them to use that habitat for their biodiversity net gain. And finally, I suggest, perhaps with our help, you prepare your own template for the BNG statement that must accompany a planning application and the biodiversity gain plan. Obviously, it'll have to be compatible with and based on any government guidance or any government templates, but you could pre-fill in some extra bits that are particular for your local authority to make it easier for developers to use. So here's just a list of documents that I think are needed. As a lawyer, I'm obviously particularly focused on documentation, and so I thought it'd be useful to list these. From the developer point of view, you will obviously have to do the metric calculation for the land within your red line boundary. You will have to create this new document to go with your planning application, and you will need to prepare and get approved by the local authority the biodiversity gain statement once you've got planning permission, but before you commence the development. If you're the landowner or broker, you will have to provide the after metric calculation that goes on the register, in fact, itself. Then either the legal agreement, the Section 106 agreement with the local planning authority, or the conservation covenant with the responsible body, and the habitat management and monitoring plan. All those are obligatory to put land on the biodiversity gain register. There will also need to be, if you are a broker or you are a landowner relying on the broker, there will have to be an agreement between the two of you that will have any financial arrangements in it and have an obligation such that the broker undertakes to maintain the land in the right habitat, etc., because it will be the landowner that may well be on the hook through the Section 106 agreement or the conservation covenant if it's not the broker who's entered into those. And finally, although this isn't really mentioned in all the documentation, I think there will need to be an agreement between the developer and the landowner, because it is the developer who is getting that planning condition added to their planning permission. So if the land is not maintained in the correct habitat and condition, although the landowner / broker will be breaching their own Section 106 agreement or conservation covenant probably, you, the developer, will be breaching your condition attached to your planning permission. So you will need some way of enforcing that. If your local authority takes enforcement action against you, you will want to take enforcement action against the landowner / broker. So you will need some sort of legal relations with that person. So that's quite a list of documents. In the February 2023 response to consultation on how BNG would all work, the government undertook to provide 15 different things before November, before the start date. I have highlighted the ones that it has actually done of those, and that's only 2.5 out of 15. And the last two were only in the last month themselves. So there's still quite a lot of ground to cover between now and November, although the government do seem to still be intending that this will all come into force in November. So here's the final poll. Given all this information, do you think that the November date will be stuck to? Well, actually, the question is phrased the other way around. Do you think the government will delay the introduction of BNG from November? May only be 2 or 3 months later. Given that there's quite a lot to do between now and then. I'm convinced that this will come into force either in November or shortly afterwards. But given all this work that needs to be done, will it happen by November? Let's see what you think. Okay, I will now go through the questions and answers in the remaining 7 minutes, as far as I get. Any other questions I don't get to, and indeed all the questions I will respond to in writing, and you will get a copies of those. So that's interesting. Half the people think that it will be pushed, but quite a high proportion don't, and the remainder are not sure. In the meantime, I am very happy to provide a bespoke version of this webinar, particularly focused on your company, for you, where you can ask silly questions that won't be in front of lots of other people from other organizations. We as a firm are delighted to support you in drafting all those documents in that previous slide. And you are automatically subscribed by attending this webinar to a newsletter we are bringing in. I think the first edition is, I've seen a draft of it, is probably going out in the next week or two. And our website, to which there is a link there, is going to have lots of useful links and information on it, that even more than it has already. In fact, I'm pleased to announce that it is going to have a simple version of a metric calculator in a few weeks, where you'll be able to put in details about your land, and out will pop the number of units you need to provide. Obviously, it is no substitute for the real metric, but it should be very helpful, I hope. If you're just getting a feel for how many units you need and what sort of land and what sort of cost this might involve. So I'm now going to start looking at these questions and answers that you've asked. Got 37 so far, so I'm not going to get through them by any means. Let's just answer them cold and see what happens. Hi, is it just applications submitted after the commencement date or those determined after that date? I think, although we will need to wait for the transitional provisions in the regulations, I think it is going to be applications submitted after the commencement date. I actually foresee a glut of applications being made just before the commencement date to avoid the BNG obligation. It'll be interesting to see if the transitional provision says that the application has to have been ratified by the local authority, has been sort of accepted before you're clear of the obligation. So you may need to want to apply a bit earlier, not immediately before the date, in case you are too late. And local authorities are going to be very busy with this glut of applications. Do we have much knowledge as to how BNG will apply to affect simplified planning zones? We probably don't have that much knowledge. I don't. But I think the distinction is that if you need to make an actual application, then you will have to fulfill biodiversity net gain. So if the simplified planning zone means you don't need to make an application, you may not need to provide it. For example, permitted development. If you can rely on permitted development rights, you don't need to provide BNG because you're not actually making an application. It's sort of done for you. So I would use that as an analogy to how it might apply to simplified planning zones, but again, that will depend on the details. Anybody have thoughts on temp works, especially below ground work such as pipelines? We have differences of opinion between ecologists and the Wildlife Trust. Well, I hope that was asked before I actually covered that. So I think that you will, temp works will still have to provide biodiversity net gain, but you will be able to rely on the land, the same land that you're developing, if it's being restored afterwards. But A, you will still need the 10% extra, and B, it'll be discounted because of the time lapse from it being lost to being regained, if you like. So it's not the full answer on its own. If you can't use as BNG new habitat any part of the application site which is being built on, will that mean a green roof can't be new habitat? And green roofs are listed in the habitat, in the list of different habitats. I'm pretty sure. I will confirm that in writing. So that will be a way of providing on-site BNG. I can't remember off the top of my head what score a green roof has. So that's definitely something worth exploring. I suspect it won't fully compensate for the score that is being lost in units, but maybe it will if you're doing it to a good condition and the previous condition of the land was poor, for example. That might fulfill the entire obligation. How are we doing? 10:29, one more. Does the planning application need to include the land being identified for BNG, thereby increasing your red line boundary and thus the application fee? If so, is there a risk of a circular 10% being applied? I think you would need to, if it's on-site land, then you would, and you're extending the red line boundary so that you can fulfill that, and you wouldn't have been able to otherwise, you will need to increase the red line boundary at the time of making the application, which probably may affect the fee. And of course, that new land will also have to apply 10%. So you will need to make sure that you don't end in a sort of massive infinite recursion of 10% on 10% on 10%. Yes, that is an issue. So you need to make sure the entire red line boundary you have scored, and whether you can provide the 10% within that, you'll need to consider. So I think I'm going to have to leave that one there. Leave all those questions there. I'm sorry that was only about 4 or 5 of the nearly 40 that were asked, but I commit to answering them in writing and providing them to you all. There will be more webinars before November and perhaps even after November. So stay tuned, you will get the bulletin, and I am always available, as are my colleagues, to ask any questions you might have at all times. So I hope that was useful. And there will be further changes before now and November, and I'll keep you up to date on those. And let's keep in touch. Have a good day, and thanks for tuning in.